Imagine the highest court in the land grilling a former president's bold economic moves like a steak on a sizzling barbecue. That's exactly what unfolded in a tense Supreme Court session that could redefine presidential authority in America. But here's where it gets controversial. Are we witnessing a power grab that tips the scales too far from Congress, or is it a necessary tool for our president to protect national interests? Stay tuned. Because this debate isn't just about tariffs. It's about who really calls the shots in our government. On Wednesday, the Supreme Court delved into the legal soundness of the Trump administration's tariff strategy, a policy that drew fire from both sides of the political aisle. Justices from conservative and liberal leanings alike expressed serious reservations about the foundation of Trump's signature approach to global trade. Leading off was Solicitor General D. Sauer, arguing on behalf of Trump. He explained that the president enacted these tariffs to combat two pressing crises: a long-standing trade deficit that had been tilting the economic playing field unfairly against the U.S., and the alarming influx of fentanyl flooding across our borders, posing a severe public health threat. To help beginners grasp this, think of tariffs as extra fees on imported goods that make them more expensive, potentially encouraging buyers to choose domestic products instead and protecting jobs. Yet the justices weren't convinced. They questioned whether Trump truly had the right to levy these tariffs under the International Economic Emergency Powers Act, or IEEPA for short, a law originally designed to give the president tools to handle international economic emergencies, but notably silent on tariffs. Chief Justice John Roberts pointed out that IEEPA doesn't mention tariffs at all. Sauer countered by saying the law's language is broad enough to allow it, and that Trump also draws from his constitutional powers as president to address national security and foreign policy challenges. For those new to this, inherent authority means powers that aren't explicitly listed in the Constitution, but are implied for the president to lead effectively in areas like international relations. Roberts agreed that tariffs touch on foreign affairs, but he emphasized a key point many people miss. These policies effectively tax American consumers and businesses, and raising taxes has historically been Congress's exclusive domain, not the executive branches. Justice Sonia Sotomayor took it further with a hypothetical that sparks debate. Under your logic, couldn't President Biden declare an emergency over climate change and use that as a green light for sweeping environmental policies? It's a provocative example that raises eyebrows. Does this open the door for presidents to bypass Congress on any issue they label an emergency? Justice Amy Coney Barrett pressed for evidence, asking if Sauer could cite any historical precedent or another part of the law where the phrase "regulate importation," straight from the statute, has ever been interpreted to allow tariff powers. Sauer stuck to his guns, insisting emergencies justify the actions. Justice Elena Kagan responded with sharp wit, noting sarcastically that if emergencies alone suffice, we're always in one. Half the world feels like an emergency at any given time. This quip highlights a potential slippery slope. If presidents can invoke crises to impose tariffs, where does it end? Justice Neal Gorsuch delivered what might be the strongest blow, arguing that Sauer's stance essentially grants the president unchecked power over everything from commerce to duties, tariffs, and even declaring war, a right explicitly reserved for Congress and the Constitution. You're claiming inherent authority covers all foreign affairs. Gorsuch challenged, what stops Congress from just handing over all its powers to the president tomorrow? Sauer replied that past court decisions limit presidential powers to a reasonable degree, and Congress could always amend the law to reclaim authority. But Gorsuch wasn't swayed, pointing out the practical hurdle. A president could veto any new legislation, requiring a supermajority in both houses of Congress to override, and that's nearly impossible in today's divided politics. As a practical matter, Gorsuch said, Congress can't claw back power once it's handed over. This exchange underscores a controversial counterpoint. Is the presidency evolving into an imperial office, or is this just a check and balance system working as intended? Switching sides, lawyer Neal Katyal, representing the challengers, highlighted that IEEPA has been on the books for 5 decades without any other president interpreting it as a blank check for unilateral tariff power. Justices grilled him on whether the law's references to regulating imports and licensing fees could actually mean tariffs. Katyal defended that they don't. The toughest query came from Barrett, who zeroed in on a messy reality. Billions of dollars have already been paid by U.S. companies to comply with these tariffs. If you win, how do you handle reimbursing that money? She asked, noting that Katyal had mentioned government promises of refunds. Katyal outlined various options, but Barrett shot back, so a mess. For beginners, this illustrates the real-world chaos. Undoing tariffs could mean complicated clawbacks, affecting businesses and consumers alike. The court might rule faster than usual, as both parties urged an expedited timeline. And this is the part most people miss. The outcome could set a precedent for future presidents, potentially empowering or constraining them in ways that shape everything from trade wars to emergency responses. What do you think? Does the president have too much power in emergencies? Or is this flexibility essential for national security? Could this ruling lead to more unilateral actions by future leaders? Or does it protect Congress's role? Share your views in the comments. Do you agree with the justice's skepticism? Or do you side with the administration's defense? Let's discuss.